All rise for Court of Appeals Division 1 is now in session.
Thank you. Please be seated. This is CV18-0276, Laveen versus Mejia. These proceedings are being video and audio recorded, also live streamed for the first time today. So we ask counsel to please identify yourselves and your client at the beginning of your argument. We also ask that you be mindful of the fact that since we are live streaming, anything that gets picked up by the microphones cannot be scrubbed. So just keep that in mind, yourselves and those in the audience. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if desired. Also, we have read the briefs and have discussed the case in conference. Counsel, you may proceed.
Thank you. Good morning, and may it please the court. My name is David Wood. I'm here with my co-counsel, Jacob Kubert of the DeSalis Law Group, and we represent Carlos Mejia, or more specifically, Mr. and Mrs. Mejia, who have moved on me and are in the courtroom in attendance today. So, Your Honor, the crux of this case really comes down to a simple question under 33-1807, specifically subsection A. And that's whether the legislature mandated or authorized the foreclosure of a personal residence solely to satisfy attorney's fees, because that's what ended up in the judgment in this case. And that's what ended up at issue 11 days after the application for a default judgment. Specifically, I would like this court to note that within the record, at the time of the application for default judgment, at the time of the complaint, nobody could know what was in a principal sum that was being demanded as part of a foreclosure of a home. And what ended up being part of that principal sum were thousands of dollars in undisclosed and unawarded attorney's fees, fines not subject to disclosure. And this litigation then took off for months, and multiple pleadings and hearings, all escalating attorney's fees solely to collect those undisclosed, unawarded attorney's fees. Assessments per the statute were not at issue as of April 14, 2017 in this matter. So the question then becomes, well, does 1807A bless that type of procedure where if you are authorized to file an action for assessments and those assessments are completely paid off and paid off even at an even greater sum, there was a negative judgment in this case because Mr. Mejia didn't know what he was going to be paying toward because there was no disclosure of what the principal sum was due. And so the question is, did 1807 just simply say, if you can file the case, you can get the home, and if you want to challenge any amount due, it comes at a continued escalating cost of attorney's fees where there is no way to escape that trap. Otherwise, you lose your home because your home now becomes the collateral for fees to an attorney rather than assessments actually owed a homeowners association. The answer is certainly no, because foreclosure, or to be foreclosed, is a remedy in Arizona. And that's where the trial court committed reversible error in this case. If you look at the foreclosure judgment, the trial court in the handwritten portion specifically rejected the argument that foreclosure was not authorized by finding, well, since you were authorized to file the claim in the first place, you can go ahead and get foreclosure. And that's where you end up with a foreclosure judgment with no money owed and a whopping bill for attorney's fees in this matter. When you look at 33-1807, it's not just A that bars that, it's the entirety of the statute. It's the entirety of the statute. Now, again, to be foreclosed is a remedy. And that's not something you have to take my word for. If you look at the final judgment at paragraph 4, that final judgment was submitted by the association in this case. And it provided that in the final judgment, the interests of the defendants herein are hereby foreclosed. So when the legislature set a $1,200 threshold or a year of delinquency, what they were setting was something for the very, very drastic remedy of foreclosure. Otherwise, you get into the territory of where the canons apply with regard to absurd results, which this case bears out that the assessments were paid, every dime of them. And then there was all of this litigation to get unawarded attorney's fees, which what we're asking for in this case is to take the next step from this court's decision in Bocchino, where this court also said, no, you can't try to just simply assess unawarded attorney's fees on a homeowner. Well, this case is the next step against that wrongful practice because it's not simply just trying to assess unawarded attorney's fees, it's trying to take the home to collect on those.
But counsel, doesn't section 33-1807A state in part that reasonable attorney fees and costs incurred with respect to those assessments may be foreclosed in the same manner as a mortgage on real estate?
That's correct, Your Honor. And what that's talking about is what the form of the final judgment can take. So there are a couple of things when you look at that sentence. One thing you'll note is that it talks about the lien for assessments. In this matter, there are no assessments owed. So what the association is arguing is, well, you can take those off the table and change it into a lien for reasonable attorney's fees. Beyond that also, though, in this matter, litigation was all being done for attorney's fees that had not been awarded. So reasonable is code for those must be submitted. Sorry.
Let me ask you, so is it your position that attorney's fees and costs are not part of the association's lien?
They're not part of the association's lien. They can be reduced to the final judgment for closing that lien. And so you can see throughout the statute that whenever there is any reciting of that, it always starts with assessments, comma. So
but in describing what is part of the lien, right? I mean, the second sentence of that section says the association's lien for assessments, comma, for charges for late payment of those assessments, comma, for reasonable collections fees, and for reasonable attorney's fees and costs. And then it goes on. But
Correct.
it's still talking about the association's lien for all of those things.
And Your Honor, it is, but you have to then look at it's for reasonable collection fees and reasonable attorney's fees. That they are only deemed reasonable when they are properly submitted to a court for a court to review based on a litany of factors to determine whether they're reasonable. So with regard to what happened in this case, what was happening was a chase for unawarded attorney's fees that were part of a principal sum. Those were never even submitted as part of an affidavit. And in fact, actually, until the court ordered a hearing on damages, nobody could even know that there were about $3,800 of unawarded attorney's fees stuffed in that principal sum. So those—
Did your client ask when he attempted to pay off the amounts owed?
That one I cannot answer, Your Honor, but it doesn't matter whether he asked, because if you look under the protective regime of the statute, if you look under subsection I, the whoever is operating for the association is supposed to be disclosing assessments only. But what I can tell you is if you look at the demand letters, which were submitted as exhibits to the damages hearing, the demand letter doesn't break those down for the client. Moreover, the problem is if we're saying it's incumbent on the client, we end up with a statute that basically says if you ask, it's at your own peril. Because as you saw in this matter where there was a challenge to whether that principal sum was correct, which Mr. Mejia succeeded on. I mean, he succeeded on that challenge, yet he still stands to lose his home just for the attorney's fees. When on 414, what should have happened is the association should have simply said, fine, we think that there's still some other amounts owed that we should submit for a money judgment. If you look at the June 2nd hearing or argument simply to vacate the default, not the default judgment, but just the finding of default, you see in the record, Mr. Kubert saying, look, all assessments have been paid. We're just talking about a money judgment. So there was always the invitation to simply reduce this to what was proper, which was a money judgment. And instead, it ended up a chase for a home for attorney's fees.
Doesn't the statute also say, give a timing of when the foreclosure can take place? And it says for a period of 1 year or in the amount of $1,200 or more, whichever occurs first. So when one of those things occurs, then isn't the association by law, whether they should have or not is a different question, but aren't they permitted then to foreclose? And of course, in that calculation of the $1,200, we can't factor in the attorney's fees or charges for late payments.
They are permitted to file an action requesting the remedy of foreclosure. So when foreclose is being discussed in subsection A, it's only talking about a remedy. But in fact, actually, the most recent amendment to the statute actually bears that out. Why put in there something completely changing the timeline if all along the statute silently was saying simply if you can get into court based on an amount of delinquency or a time of delinquency, you can get a home. That then leaves the remedy of foreclosure, an equitable remedy at that, completely standardless and ends up with what you have in this case.
So then your position is that the association may seek the remedy of foreclosure, but when the homeowner makes that payment of the underlying assessments, then the association loses the ability to go forward on the foreclosure, much like in California's statutory scheme.
Exactly.
But doesn't California's statute read very differently from ours?
It's written differently, but the substance is identical. It's simply our statute simply talks about the timing up to an event, and California simply talks about the timing after an event. But it still sets a threshold for foreclosure because foreclosure is a remedy. So I would agree, I certainly concede it's written differently. In addition, you see that the California Court of Appeals was motivated by identical other terms in the California statute, which was that it had a protective payment mechanism, much like our subsection J, that said if money is paid, it goes to assessments first, only after those are satisfied. Well, that subsection means little to nothing if paying those doesn't allow you to then possibly challenge some other amounts for your home, unless it comes at the peril of we're going to have really expensive contested hearings and our attorney's fees for that will then be satisfied with your home.
So then under your interpretation, an association could sue to foreclose against a homeowner who owes less than $1,200 in unpaid assessments or is delinquent for less than a year on the assumption that one or both of those will occur before judgment is entered. And
No.
as long as it happens before judgment is entered, then the suit can go forward.
No, Your Honor, because an ingredient of subject matter jurisdiction for filing a claim is that you have a lawful right to the remedy. What the association is arguing is that they're trying to say that the remedy is simply tied into the claim. And so long as they can file the action, they always get the remedy, regardless of what the remedy is tied to. But of course, this court sees all the time injunctive actions where, yeah, you absolutely had subject matter jurisdiction to file for certain injunctions, but circumstances change, which would be which would affect and again, injunctions are also where the trial court acts as an equitable court with regard to remedies. So no, the threshold, because it is necessary for that remedy, you can't file because you can't meet a subject matter jurisdiction threshold unless you have a right to that.
But here when they filed, they met the threshold. You're saying the payment of $5,000 reduced it under that.
absolutely. Because when it comes to has been delinquent, we're talking about an event that has to go forward to the time that the court makes the foreclosure decision, because foreclose is the remedy to bar or destroy the equitable right in property, which does not happen until the final judgment. And that's why the final judgment was actually written to that exact effect.
But isn't, let me see if I can understand your position as to the amendment, the subsequent amendment, which includes the words, as determined on the date the action is filed.
Right.
Doesn't that weigh in favor of the association? So the statute or the section begins with a description of when the association's lien may be foreclosed, right?
Correct.
And it does include reasonable collection fees and attorney's fees in the association's lien, in the description of what's in the lien. But then it says for a period of 1 year or $1,200 or more, whichever occurs first, as determined on the date the action was filed. So how do we say that it doesn't mean on the date the action is filed, it means on the date that the parties show up in court to obtain a foreclosure judgment?
Are you asking under the amended version?
It just seems like you're asking us to read it completely in the opposite way.
The prior version?
No, the amendment that you say supports your position.
If you look at what happened during the committees, what they asked is for there was actually a stated fear that homeowners associations were actually saying that the $1,200, since it was a past tense, didn't even require you to have $1,200 due at the time of filing the claim. And so you see in the committee somebody saying it has to be forward going.
I'm not looking at the committee. I'm looking at the words in the statute.
That's correct.
I'm looking at the text.
Right. And again, but if you look at the unamended version, the association's argument doesn't tie to anything. So it can be a past tense event of 2 years or 1 year by that argument, that if you had previously been in delinquent of $1,200 or a year, well, so maybe the homeowner comes to you and says, I agree, let me pay these. And the association says, well, we think that we have a whole bunch of costs. We're going to file the claim anyway. Under an interpretation of the unamended version, that's okay, because it's just simply a past tense event within the last 3 years. And that's why the association has argued so strongly that no, it has to be the time of coming to court, because they had to find some limitation that the court would find acceptable. The problem is that if you look at how the statute works thereafter, that then means that the threshold for assessments is absolutely meaningless to the remedy still, either post-amendment or pre-amendment, which is an equitable remedy. And even if we say that in the second sentence that the foreclosable lien includes reasonable attorney's fees, the problem is they're not reasonable until they're submitted to the court. So how can you have a lien mid-litigation for reasonable attorney's fees that have never been submitted to a court? And so that's why we submit that the more proper reading is that the lien that actually becomes part of the the foreclosure judgment then includes those submitted fees. So
your position is that the court cannot award reasonable attorney's fees to be determined at a later date?
It can award those to be awarded at a later date, but in this case, what you saw is a bunch of stuffed hidden attorney's fees that weren't going to be submitted by affidavit, and that was the sole goal of the litigation for months, and that becomes the sole basis for what is then called reasonable attorney's fees and a foreclosure judgment for no assessments owed. And Your Honor, I'm at the 2-minute mark, so if I could, I would like to reserve that time.
Sure. Thank you.
Yep. Okay. Come on.
Good morning. May it please the court. My name is Chad Gallagher, attorney for Laveen Meadows Homeowners Association. And as as opposing counsel pointed out, the crux of this matter truly is an issue of statutory interpretation. The question of the remedy that is provided by statute for the association of foreclosure, the question is, how does an association get there? Fortunately, the statute also provides a guideline on how the association gets to the statutorily permitted, the statutorily prescribed remedy of foreclosure. And that route is that one of two prongs must be, or triggering events must be satisfied. First of all, the statute says the association must prove that a homeowner has been delinquent in the payment of assessments in the amount of $1,200, or that the homeowner has been delinquent in the payment of assessments for 1 year. But then it includes the phrase, whichever occurs first. That qualifying phrase at the end of that sentence requires that as part of this analysis, the court be able to pinpoint the location on when in time those events occurred, which one occurred first. And whichever occurs first either has been delinquent $1,200 or in the amount or assessments unpaid for 1 year, then whichever those occurs first opens the statutory bars that would otherwise prevent the association from pursuing foreclosure. Once those.
Why does it matter if it's not over 1,200 or if it's more than a year? It's no longer delinquent. If the total amount was $1,200 and someone submits a payment of $2,000, are either of those conditions satisfied at that point? Can you go forward?
Yes, the association believes he can go forward because the lien.
But if the only thing that was owed was $1,500. And they come in and give you a check for $2,000, you can proceed with an action to foreclose?
When you say everything that was owed, that would include attorney fees and costs?
Well, the only thing that's there hasn't been a judgment yet for attorney's fees or everything else. The only thing that's that you're entitled to at that point that there's a judgment for would be the delinquent fees. Let's say you hadn't incurred attorney's fees. And there's an amount of $1,500 that's owed, and it's been owed for a year and a half. Okay, if you file something and saying we're going to foreclose on your house, and the homeowner comes in and says, here's $1,800. Can you go forward because it's been more than a year? You can go ahead and foreclose because you've now incurred some attorney's fees in filing this, and you want more than $1,800. You're entitled to foreclose. You have that as a remedy.
The statute, as Judge Cruz pointed out, includes not only assessments. Now, the valuation of whether or not the foreclosure matter can be filed or commenced, or whether or not the statutory bars are opened, is an evaluation based on assessments only. But the lien includes not only assessments, but also reasonable attorney fees and reasonable costs. And so, if in this case,
but I thought it was only if the owner has been delinquent in the payment of money secured by the lien, excluding reasonable collection fees and reasonable attorney's fees and charges for late payment.
Whichever occurs first. And when one of those events occurs first, it opens the statutory bars to allow the association to proceed to the remedy of foreclosure. In this case, defendant came and made a payment, even though he had failed to pay for 5 years, any assessments. The defendant then came and made a payment at the 11th hour right before the default hearing that did resolve the assessments. However, that payment did not resolve the other elements of the lien.
Right, but this says the remedy for foreclosure seems to be if you've been delinquent on the payment of money secured by a lien, but excluded from that lien is collection fees, attorney's fees, and charges for late payments. Am I reading that wrong?
I think it is read differently, Your Honor. Also helpful in this analysis is the reference to may be foreclosed in the same manner of a mortgage. Mortgages are foreclosed under.
Right, but then you get to only if the owner's been delinquent in the payment of money secured by the lien, but we're excluding from that amount the attorney's fees. You have to have an amount that gets over $1,200 excluding the attorney's fees and.
But the way this is written, this allows for. This essentially imposes statutory bars and explains when they are removed so the association can go. So has been, even if a homeowner comes and pays, that is still true, that they have been delinquent in the past. The statute does not say they are delinquent currently today as the date the judgment is entered, but rather has been delinquent.
But now you're proceeding on an action for reasonable attorney's fees that haven't been assessed by anyone yet. How do they know what reasonable attorney's fees are to be able to pay them?
Just as what happened in this court, there was an evidentiary hearing on what was reasonable, what should have been included in the principal balance, and also application for attorney fees was submitted to the court.
But in deciding whether the action can go forward, if they've paid, it says you can't go forward unless the amount of the lien, which excludes reasonable attorney's fees. So you're saying you can go ahead and they would have to know that they need to pay off all of your attorney's fees, or go to trial and say these attorney's fees are not reasonable? Is that
the language does not exclude attorney fees and costs from the lien. The language of the statute expressly explains that attorney fees and costs are part of the lien. When you're evaluating whether you can proceed with foreclosure, the question of whichever of those statutory mechanisms occurs first, did the event arise where they were $1,200 in assessments delinquent or 1 year delinquent in assessments? Once one of those events occurs, it continues to be true, even if they do submit a payment for assessments. And so then the concerns raised by defendants regarding the attorney fees, they are all subject to review by the court. This particular case is very different from the Bocchino case that appellant cited. In Bocchino, the association, there was no pending open action for the court to review the fees. There were fees incurred not related to a collection of assessments, but they were fees incurred related to an injunction against harassment. And so those fees were not sought in Bocchino, but then the homeowner went to sell their property and the association said, well, in order to sell without any judicial oversight, you're going to have to pay all those fees. And this court said, no, that's not the appropriate way to proceed. This matter is very different because the attorney fees and costs that we're talking about were attorney fees and costs incurred to collect the unpaid assessments, which by statute are part of the lien. And it wasn't the association. Well, there's significant judicial oversight in this case. There was an evidentiary hearing to establish what amount should be included as part of the principal balance of the lien. And the trial court found and expressly wrote on the judgment that based on the language of the statute and on the language of the contract, that it was appropriate for the association's lien, the foreclosable lien, to include attorney fees and costs. And because the association proved that the lien had been delinquent without having been resolved, without ever having been resolved, the lien had been delinquent in the amount of $1,200 or 1 year, the association was able to go all the way to the remedy of foreclosure, even though just the assessments had been paid. My reference earlier to the mortgage statutes, I think also is instructive and helpful in this case, because 33-725, which is the mortgage foreclosure statute, explains, well, first of all, 1807 says we proceed in the same manner as a mortgage. So the procedure that's identified under mortgages is instructive. In 33-725A, it explains that the moving party is entitled to the full amount of the debt. So we'll call that the principal. Then in subsection B, it says, shall get a judgment not only for the principal, but also for costs. So the statute expressly allows now in additional charges for not just the principal, but also for the costs. Subsection C then, which talks about redemption, explains that if a homeowner wants to stop the sale, then not only must they pay the principal, which is the total amount due identified in subsection A, but they also must pay the costs, these additional amounts that are statutorily allowed in the mortgage foreclosure process. Taking that same analysis to our statute, basically the principle is this: when a statute specifically allows for amounts to be included in the lien, those must be paid in order to stop, or in order to fully redeem the property, or to stop the sale, as is expressly identified in the mortgage foreclosure statutes. And so because in this case, the statute that we are dealing with, 33-1807, expressly explains that the lien includes reasonable attorney fees related to collection of those assessments and reasonable costs incurred in relation to collection of those assessments, and that the lien may be foreclosed. Excuse me. Provided the association can prove that the homeowner had been, that we can point to a point in time where the lien was included at least $1,200 in assessments or 1 year's worth of unpaid assessments, when we can point to that moment in time, then the entirety of the lien is subject to the remedy of foreclosure, even if the homeowner comes and makes a partial payment to resolve just the assessments, because those statutory bars have been removed, and now the remedy of foreclosure is available to the association. The end result of that is that in some instances, such as in this case, the ultimate judgment that was obtained did include just attorney fees, but they were attorney fees that were expressly, by the language of the statute, included in the lien. And because the association proved that the lien did meet the statutory qualifications because the owner had been delinquent, the statute again does not require that we review at the time of the judgment is delinquent in assessments or is currently delinquent 1 year or $12,000. Excuse me. But that language has been coupled with whichever occurs first, puts it to an analysis at some previous point in time that we can pinpoint that then opens the avenue and allows the association to proceed to foreclosure as a remedy. With respect to issues regarding the attorney fees in this case, which defendants counsel have pointed to numerous times, refer to them as unadjudicated attorney fees or attorney fees that would be disallowed. In this particular case, the association's position has been nothing was left unadjudicated. The attorney fees, the pre-litigation legal fees, which the association submits that pursuant to the statutory scheme, they were expressly allowed to include as part of that foreclosable lien. They were the subject of an evidentiary hearing where the court made a finding of fact that based on this language that the association was entitled to pre-litigation legal fees as part of its foreclosable lien. Now, substantively or functionally, even though the court made that finding, the judgment in this case, the facts of this case, based on the court's mathematical equations at the end in calculating the principal balance, the functionality is that not a penny of pre-litigation legal fees was awarded to the association, and not a penny in fines was awarded to the association either. And this is now on page 11 of their reply brief. The defendants put together a chart identifying how they came up with $3,800 in pre-litigation legal fees. That figure is not correct. The chart is not correct. What defendants failed to identify, and this is on item number 51 in the index of record, there's a charge on July.
I'm sorry, counsel, item
51.
Item 51
Thank you.
in the index of record, excuse me, is a ledger that identifies every charge, every penny that went into the principal balance that was the subject of the evidentiary hearing. And on July 15th, 2013, the defendant identifies a charge for $966 roughly. However, defendants failed to account for the fact that on that same day, there was a credit for attorney fees in the amount of $966, the exact amount. The net result of that charge and credit is zero. So the actual amount of pre-litigation legal fees was not $3,800, but was rather closer to $2,800, which then, when we get to the end of this case, where the judge made her calculations as to what amounts should be included and part of the principal balance, the judge subtracted $3,400 in legal fees from the principal balance. However, as the association explained in our answering brief, that in order to get to the principal balance, the association had already subtracted that $3,400. Those related to foreclosure-related legal fees, not pre-litigation legal fees. The double subtraction then of $3,400 meant that the entire $2,800 in pre-litigation legal fees was removed from the judgment. Not a penny was awarded. Not only that, but there was still an additional $560 that was removed from the principal balance. Defendants identified $480 in fines that were included in the judgment, but that additional subtraction of $560 meant that not a penny in fines was also included in this judgment. So ironically, even if the court were to find that attorney fees pre-litigation and fines pre-litigation setting aside the fact that the contract in this case expressly allowed for fines to be part of the lien and pre-litigation legal fees, even setting that aside, the judgment functionally did not award a penny of either of those amounts because of the double subtraction that the court did in rendering the amount of the final balance of the judgment. Defendant also argues regarding Rule 60 and why the judgment should be set aside under Rule 60. However, every single one of the Rule 60 arguments is tied back to the statutory interpretation. Another element that I think is important in reading 33-1807 with respect to the difference in the types of liens is that 33-1807, if you continue on, first of all, it starts out talking about the assessment lien. As we've discussed, the assessment lien, which includes attorney fees and costs, and can be foreclosed provided one of the statutory requirements is satisfied. And then as it continues on, it also explains there's another type of lien that associations have. It includes a lien for monetary penalties and also late charges for monetary penalties or fines and attorney fees and costs related to those fines that can be imposed under ARS 33-1803, which is the fine statute that allows associations to impose fines. Then the final sentence of that statute, which is sometimes, and defendants did this in their reply brief, but the final sentence then talks about when a lien may not be foreclosed. The association's lien for monies, so this is that language, the association's lien for monies, and that word there, monies, is broad enough to encompass any conceivable charge that the association could post. So the lien for monies, other than, and then it gives us a list of other thans. What is not included in this particular lien we're talking about. And it again says, other than for assessments, for charges for late payment of those assessments, for reasonable collection fees, and for reasonable attorney fees and costs incurred with respect to those assessments, which we see those are the exact amounts a couple sentences earlier that the legislature said those amounts are part of the association's foreclosable lien. Now, down here in the final sentence, again, it says, okay, now there's a lien that cannot be foreclosed, but that lien does not include, that lien is other than the amounts identified a couple sentences earlier that can be foreclosed as part of the association's foreclosable lien. It's often that that final sentence is defendants try to impute it, the significance to affect the assessment lien, but it is different and distinct. The association's lien for assessments that can be foreclosed does include attorney fees and costs, and it can be foreclosed once the statutory bars are lifted. The difference between the associations or the Arizona statute and the California statute also is very significant because as Judge Cruz pointed out previously, the California statute does not identify when a lien can be foreclosed, when the statutory bars are removed for foreclosure, but rather when they are imposed. That statute is written such that if these events occur, boom, no longer can you proceed with foreclosure. Arizona statute is written exactly the opposite. It identifies when the association's lien may be foreclosed. And that avenue is open, those doors are opened once the association proves that that lien has been delinquent for 1 year or $1,200, whichever occurs first. And as far as concerns regarding the reasonableness of attorney fees that are incurred in that process, that is why the process is with judicial oversight through a judicial foreclosure action. The association then requests that the judgment of the trial court be affirmed. Thank you.
Thank you, counsel.
Thank you, Your Honor. Now, you heard an argument, the reference to what's at issue here, the remedy of foreclosure. And that is how the statute is written it strips everything else away and it talks about what actually matters to the legislature, which are actual assessments owed to the association as far as allowing that remedy to be imposed. The foreclosable lien is a question that then only comes into effect after that. The problem with interpreting the statute to mean if you come into court, with allowance to ask for that remedy is, as a homeowner, you can never get a definite number, or if you try to demand a definite number to actually save your home, it only comes at a continual multiplier of attorney's fees after attorney's fees after attorney's fees. And then you end up exactly where Mr. Mejia ended up in this case.
You end up with a judgment, even assuming you can't foreclose. Those are presumably fees that are authorized under the contract, and you've got a judgment against you in that amount. So how is that much different, other than you're just saying it's a judgment, but they can't foreclose on my house?
It just ends up as a money judgment, and that's what's at issue here is Mr. Mejia's home. That's what we're here about, is Mr. Mejia's home.
Right, but he has an incentive to try to get the information to keep from getting a money judgment in that amount. So why is it that much different to try to ask for a breakdown? I guess I wasn't following the first part of your.
Well, the issue is that you can see at the very beginning of when Mr. Mejia had counsel on this, there was the invitation. Just let us know what is actually owed and for what, and submit for attorney's fees. You can have a money judgment. And that was rejected. No. Pay us everything without actually looking behind the curtain was the demand. And that's why there is a foreclosure judgment in a negative amount for attorney's fees only. And that is something that the legislature did not authorize in 1807A. It could be converted to a money judgment. We've never disputed that. But as of April 14th, there were no assessments being collected, and it then gets to the remedy was no longer authorized, and Mr. Mejia, after that date, was the prevailing party.
Thank you, counsel.
Thanks.
Counsel, we thank you for your arguments. This matter is now under advisement, and we will issue a written ruling in due course. We're at recess.